Okay, let's quickly revise till the time others join. We have started with the offer and acceptance, and wherein we have discussed the meaning of offer, where we have discussed that when a person signifies his willingness to do or not to do something with a view to obtain assent, yes, from that other to such an act or abstinence, he is said to have make a proposal. So we have already discussed the essential elements in detail. So in case of any query in between related to any point, you can ask in between, right? Then with respect to the meaning we have discussed कि two parties होनी चाहिए, subject matter होना चाहिए to do or not to do something, and the person has shows his willingness so that he wish to enter into the contract, and this willingness is with respect to that he is going to obtain yes with respect to such act or abstinence. So there are two parties, offerer and offeree. Until the person accepts the offer or enters into the contract, he does not become promisee. So generally when we use the term contract, we use the word promiser and promisee, but till the time it is not turned into the promise, so the parties remains as offerer and offeree only. Then we have discussed the other essentials of offer. So there should be an expression of willingness from the point of view to create legal obligation. So, if the intention of the party is not to have legal obligation, then such an offer will not result into the contract. Then types of offer we have discussed: express offer, implied offer, specific offer, and journal offer. So with respect to the specific offer, we have to understand that when a person to whom the offer is being made specifically, then such a person has the right to accept the offer. Other than that person, no one else has the right to accept that offer. And in case of journal offer, we will be discussing in detail in today's class itself. Then we had discussed about the essential elements or rules regarding the valid offer, wherein the first essential we had discussed that offer must be capable of giving rise to legal consequences and to have the legal relations. So in that we have already discussed in detail Balfour versus Balfour case. Then, second essential, we had discussed that the offer must be clear, definite, certain, or capable of being made certain. It means that an offer with respect to which subject matter we are entering into the contract must be clear, or there should be certain indications, certain examples, or samples which makes it clear, or there are other rules where there is the clarity that about which subject matter we are going to enter into the contract. So in that case, if there is any kind of vague offer or there is no clarity about which subject matter we are going to enter into, so even though that is accepted, but it will not give rise to the contract for the want of that it is not regarded as valid offer in the eyes of law. Then the next essential we have discussed that an offer must be distinguished from mere declaration of intention. So when a person is just showing his intention, he is not willing to do that thing. Because when we talk about the definition of offer, we says a person shows his willingness to do or not to do something. So here the person is just sharing his intention. He is not willing to do that thing right now. So in that particular situation, there is an intention, declaration of intention means that offer will be made in near future. So in that case, once when the offer will be there, that can be accepted. But at present, there is no offer. There is just an intention that the person is planning to make an offer related to certain subject matter, but that does not satisfy the condition that that particular point in time there is a willingness to do or not to do something, or there is a willingness to obtain the assent of the other person with respect to that particular aspect. So दोनों चीजें मिसिंग है, तो इस केस में वो वैलिड ऑफर को राइज नहीं देगा. सो वी नीड टू अंडरस्टैंड the difference between the declaration of intention and an offer. An offer will give rise, once accepted, to legal obligation, will give rise to a contract, but declaration of intention is not an offer, so is not capable to give rise to the promise, hence to an agreement and to the contract. So there will not be any rise of legal obligation in case of declaration of intention. The next essential says that offer must be different from an invitation to offer. So for an offer to become a contract, its acceptance is needed. So once the offer is being made, then it can be accepted. But once the offer is not being made, there is just an invitation to offer wherein the party is inviting the other party to invite the offer. So in that particular situation, the person who invites the offer may accept the offer, or may someone else is in the position to accept the offer, but invitation to offer does not give rise to the legal obligation, or and as a result does not give rise to a contract. So in that particular situation, invitation to offer will give rise to offer, and once the offer is accepted, then it will give rise to the promise. So in this case, invitation to offer is different from an offer and is not regarded as an valid offer in all scenarios. Examples we have already discussed, that price catalog of prices, tenders or quotations, or where parties have uh, goods are being displayed with the price tag, etc. So in all these situations, the particular situation is the invitation to offer. It does not give rise to the offer. The next, the examples are we have already discussed, that advertisement for sale of goods by auction is an invitation to offer. Then display of goods is invitation to offer. Catalog and price list, inviting tenders, all these are invitation to offer. So hence once invitation to offer is being given, so acceptance of such invitation does not give rise to the promise. So acceptance of such invitation means that the other person is going to make an offer, and the first person inviting the offer or any other person will accept it, and in that situation there will be a rise to a contract. Then when we talk about declaration of a statement, so sometimes when we ask someone that what is the price of this particular product, and the other person replies for the price, so that does not mean the other person has accepted the offer. So in that situation, the mere declaration of price is not an acceptance. So we'll discuss in detail that when the acceptance will take place. Then another essential is an offer must be communicated to the, we say, one second. Yes, please. So when we say this essential, next essential, so this next essential says that an offer must be communicated to the offeree. So once the offer is being made, so it must come into the knowledge of the offeree. Offeree means to whom it is intended to be made. So it is until unless it is communicated, it will not have any effect. So in this case, we say that offer must be known to the acceptance, otherwise it will not give rise to the contract. So here we just need to understand that once the off one second. So once here we have to understand that whenever the offer is being made and once it is accepted, then in that case it gives rise to promise, and keeping in mind that all other essentials are present, we say that there is a contract. And as per this, it gives rise to your legal obligation. So legal obligation means that parties are bound to perform. So they need to perform, they cannot set it aside. And sometimes what happens that when we are working, so we are working voluntarily. It means that we did something, but that was voluntarily. It was not out of the legal obligation which resulted from the contract. So, in this particular situation, such an obligation or such a performance which has been done voluntarily, it does not consider as the promise. So, unless offer is known to the offeree, there can be no acceptance and no contract. It means that if there is no offer, but you have done something voluntarily, so it will not be considered as the acceptance, or it will not be considered as the, we can say, as the part of the contract. So in that case, we have to understand that there is that offer must be communicated or must be in knowledge of the person to whom it is being made. So if it is not in the knowledge of that person, it will not regard as a valid offer. So in this particular case, we offered a reward to anyone who will find his cat, lost cat, and found the cat and brought it without knowing the offer. He was not entitled to the reward. So it means that when Q has performed this particular activity, so he has performed it voluntarily. He has not performed it as the legal obligation arising out of the contract. So we need to understand that without communication, if someone else is performing, so that performance is not accepted as a legal obligation. So there is no contract until unless the offer is being communicated to the other person and other person perform on the basis of such an offer. So there cannot be an acceptance until unless the offer is known to the other party. Similar type case is here, Lalman Shukla versus Gauri Dutt. So in this particular case, it generally come in the exam, or sometimes it is asked. So I think spelling are not correct, so we'll check it. And in this particular case, P's son was missing, and he sent his servant out to find him. In the meantime, announced a reward of rupees 10,000, and for who will bring the son back. In the meantime, servant found the son and brought him back, and he was not given the reward, that he was not aware of the offer. So it means that communication is needed. So when servant went out, so and servant performed the activity, right? So this performance is voluntarily perform the activity of finding the son. So this was not as a legal obligation of the promise, right? So in this particular case, he is not entitled for the reward, because will be entitled for the reward if there would have been a contract, and out of that contract the legal obligation would have been there, and out of the legal obligation the person has performed his part of promise, right? So in this particular case, we understand that this promise or this performance should be out of the contract. So if there is, the offer is there, the offer is not into the knowledge of the party, so even if there is only acceptance of that, so this acceptance will not result into the contract, right? So out of the because of that contract, he is liable to pay the reward, and in this particular situation he is not entitled. Here at later stage a concept will come, that if there is a promise to pay, in this case out of the gratitude, even if the servant was not aware of, and out of the gratitude the person has paid that reward to the servant, so then in that case, if he has promised at later stage, then in that case it will be enforceable by law. But this particular point in detail we will be discussing in the chapter of consideration. So as of now, we just have to understand that the activity, that the particular offer should be accepted when there is the contract, right? So there is the, once the offer is being made, it needs to be accepted. Then let's go to the next condition. One second. I don't know. It's, I think my system got hanged, so please adjust, wait for a while. Okay. Is my screen visible to all of you?
No, ma'am.
No, ma'am.
Okay, I think something got hanged. Wait for a minute. I think we need to log in again.